So the next case set for argument is Meghan Daubenmire versus Chad Daubenmire. Thank you. Case number is 18CA0045M. The appellee did not file a brief, so we will hear just arguments from the appellant. We've read the briefs, are ready to proceed. You'll have 15 minutes.
Thank you, Your Honor. I'm Ted Lesiak. I'm representing the appellant Chad Daubenmire. In this case involves a modification of spousal, a requested modification of spousal and child support. Basically, the error alleged is that the trial court erred in overruling objections to the magistrate's decision failing to modify Mr. Daubenmire's child and spousal support obligation. Specifically, we're claiming that the trial court abused its discretion in determining that there was no change in circumstances to modify child support, no substantial change in circumstances to modify spousal support. In addition, the trial court abused its discretion in failing to comply with revised code section 3119.79 in its determination to not modify Mr. Daubenmire's child support obligation.
Is it your argument that the court would have had to have done a worksheet, child support worksheet, to determine to make the determinations that it did in this case, and that because it did not utilize a worksheet, that was error?
Yes, Your Honor, because specifically the statute itself says that the court shall recalculate the amount of support that would be required to be paid under the child support order in accordance with the schedule and applicable worksheet. In this case, the court never got to that particular exercise. The court merely stated that there was no change in circumstances. And specifically, they went to that particular conclusion based upon the magistrate's conclusion that Mr. Daubenmire in his testimony during the hearing was basically not to be believed. However, in this particular case, there was the accountant testified. Now, for some background, Mr. Daubenmire is the 50% owner of two companies. One is RMD Companies, which is a construction company, and the other is Dauby Properties, which is basically a real estate holding company. Mr. Daubenmire's income comes from these two particular companies.
Okay, can I ask you a question at that point?
Yes.
The agreed income that initially generated the spousal support and the child support, in what way was that based on either the company profits or his income tax return? Because my reading of it has an agreement far above what either of those two things documented.
That's correct, Your Honor. And there was not a hearing with regard to that. There was an agreement with regards to the income. At the time, the matter went to trial in 2014, and the parties had the tax returns of both the companies and Mr. Daubenmire from 2013 as the basis for his income at that time. At the time, Ms. Daubenmire's counsel claimed that Mr. Daubenmire was not reporting expenses paid by RMD Company, personal expenses, that would have raised his income to in excess of $200,000. The amount agreed to in 2013 was basically an acknowledgement that that particular situation did exist, but not to the extent that Ms. Daubenmire was claiming. So the parties came to an agreement with regard to that $169,000 figure. And that was based upon, and that's our argument, basically. RMD's tax returns in 2013 show gross sales of over $1.5 million. In 2014, that dropped to $950,000 approximately. 2015, $1.2 million. In other words, his income at that time came from those two companies. In 13 also, I neglected to say, there was a question of some income that he works in cash as a bartender also. There was some income there. When this matter came to trial in 2016, the income tax returns, both personal and business, had been completed for 14 and 15, not 16 yet. The evidence was is that there was no income coming from bartending at that time, that it was just from the companies that he owns.
That was important in the court's decision, I think, right? The fact that he had unreported income affected the court's view of his credibility, the fact that the accountant relied on information coming from your client and didn't have any outside source to corroborate it. I remember the court's entry. Found them not credible because of that.
Right, well, and that's part of the question. There wasn't a question in 2013 that there were personal expenses being paid by the company. In fact, obviously, they were married. Ms. Daubenmire was aware of it. We did not argue in the trial court that that was not still occurring, but that based upon the amount of money available to be used because of the loss of income to the companies, that it would be impossible for that particular income figure to be used in these circumstances.
But I guess where I'm struggling is, I'm going back to that initial agreed upon income figure.
Yes.
It would have been impossible under any circumstances because that agreed upon income figure didn't reflect any of the things you're talking about now, or most of the things. I mean, obviously part of that was in it. So I guess I'm trying to figure out how you agreed upon this and then not all that many months later say, oops, change/substantial change.
But Your Honor, the agreement was based upon an income figure of $1.5 million. And if I could get to what happened with regard to RMD and what the testimony was, at the hearing, the accountant testified that, yes, it's true, that she based her income tax preparation upon information provided by Todd Daubenmire, who is Chad Daubenmire's brother, who is his partner, to do this. She also stated that she believed that she had included personal expenses into the individual tax returns she prepared for both Chad and Todd after she prepared the R&D tax return. And that basically the R&D tax return would not reflect any personal expenses paid. She said she did not necessarily just rely upon what Todd Daubenmire presented to her, that she did rely upon bank documents such as statements, deposits, that type of thing, to verify what Todd Daubenmire had presented to her. And as a result, that's where we believe the court abused its discretion. The court, in fact, says that the tax returns and the accountant's testimony was relevant, applicable, and helpful to the court, and actually in its decision listed the actual dollar figures from those tax returns. Inexplicably, the court then ignores all of that and says, we're going to find no change in circumstances because we don't believe Mr. Daubenmire. However, those documents are relevant to making a determination as to whether or not there should be a modification. Specifically, as stated previously, it was an abuse of discretion not to try to calculate some amount of income here with regard to the modification of child support. Even if the court determined that the $169,000 figure used in the agreement in 2013 was the specific figure that should have been used, the court should have done a worksheet and made that determination that there was no 10% difference in the modification to allow the modification of child support. Obviously, the spousal support, when the court's looking at modification of spousal support, it's a different standard, different revised code section, 3105 18C. You have to look at those factors. But the court's failure to actually look at the reduction of the company income that could even allow that type of lack of a better term, under the table income of the paying of personal expenses through the company, it was not possible in 2016 because of the reduction of income to the R&D company. Just for an aside, Dobby Properties is the holding company. Dobby Properties had the same amount of income every year. So that wasn't really a consideration, other than there might have been more losses one year than others, but it wasn't significant. What was significant was the tax returns that the court neglected, failed, and ignored. And as I stated in my brief, even if we took, Mr. Daubenmire's income on his tax return in 2013 was $109,760. The parties agreed to impute income up to $169,560. If you took Mr. Daubenmire's personal tax returns from 14, 15, and the account said they'd be similar in 16, and imputed that 35% for the personal expenses paid, Mr. Daubenmire's income would have been $86,550. I mean, there was evidence sufficiently presented at the hearing whereby the magistrate could actually do this calculation and even include amounts of quote-unquote personal expenses in that calculation if she didn't believe Mr. Daubenmire's testimony, which obviously she did not. However, it was an abuse of discretion not to look at the bigger picture with regard to the tax returns and actually do a calculation with regard to child support. That also, obviously, not looking at the tax returns and what the actual income should or could be was an abuse of discretion with regard to the modification of spousal support.
So even if a court concludes that the information is unreliable and the worksheets are going to result in an unreliable figure, which you're saying is not the case here because it could have added 35% to cover any of those unreported expenses.
Correct.
But they would, even if the court feels the information it's receiving is unreliable, they would still have to do the worksheet.
Well, if that were the case, Your Honor, I believe that the court would still have to do the worksheet and say that the information we have is not sufficient to modify child support, and therefore the calculation is what it was at the time of the previous order, which in this case was a divorce decree. As a result, we are asking the court to reverse the judgment of the Medina County Court of Common Pleas Domestic Relations Division in this case and remand it for further proceedings with regard to recalculating the amount of support. There are no more questions?
All right, thank you very much for your
Thank you.
argument. We'll take the matter under advisement, issue a decision in due course. Of course, you will see, clerk will mail you a copy of the decision on the